speaker. So do we have any cards? Thank you. Okay, we're doing something a little bit different, a consent agenda. All the board members have had the board package. There's 3 items that we put on the consent agenda this time. We don't need to discuss these individually. Any items that may be removed from the consent agenda by a member, the executive director, or airport legal counsel for discussion before the remaining items on the consent agenda have been moved and voted. Does anyone have any items to remove from the consent agenda? There are 3 items: signature flight support, a special event request, the noise abatement report for the month of March, and the security system enhancements contract award.
Motion to approve the consent agenda.
Second.
Okay. Any other discussion, comments, questions? Okay. All in favor, say aye.
Aye.
Any opposed? Consent agenda passes. Federal, state, and municipal input. Claire, do we have anything?
No, sir.
Okay. And then that leads us to the financial report, the presentation of the March 2022 financial report, and Randy Nobles, our Secretary Treasurer, anything to tee it up?
No, I'll just turn it over to Jada. We're in the, the 5th or 6 months of our fiscal year, so we're halfway through. Hard to believe.
That will turn it over to staff. Jada?
Thank you, Mr. Chair. Jada Stewart, Accounting Manager. In your package is the financial report through March 31st, 2022. As you can see, total operating revenues year-to-date are approximately $3.3 million. Total operating expenses year-to-date are approximately $1.8 million. And net income before depreciation is approximately $1.5 million. Overall revenues are 9.2% above budget year-to-date, primarily due to the seasonal nature of fuel flowage and customs revenues. Expenses are down approximately 33.4% to budget year-to-date due to project expenses incurred but not yet received. On behalf of Airport Management and the Secretary Treasurer, we respectfully present the March 2022 financial report to the Airport Authority.
Okay, thank you, Jada. Look for a motion to approve the financial report.
So moved.
Cheryl? Second from Bob. Any questions of Jada? Any comments halfway through the fiscal year? Okay, hearing none. All in favor of approval, say aye.
Aye.
Any opposed? Unanimously passes. Thank you, Jada. Next is tenant reports and requests. And our first item is Premier Aviation of Boca Raton, Phase 3 request for a time extension. And there is, we're here to consider Resolution 4522 of the Boca Raton Airport Authority approving the 11th Amendment to the Premier Aviation lease. So, Janet, will you introduce that?
Yes, thank you, Mr. Chair. As the board will recall, at the March meeting, Premier presented a request for a 6-month extension on the permit and site plan approval requirements that are articulated in the previous amendments to the lease. The original request made by Premier was for a 4-month extension. However, we felt that 6 months might be more appropriate to prevent having to come back to the board in case there was a protracted review period that the city would impose in those permit applications. At that meeting, the board asked for 2 things. The motion for the 6-month extension was tabled for this meeting, subject to 2 conditions. The first condition was that Premier provide some background and documentation on their process, or their progress in obtaining, or efforts rather, in obtaining permit and site plan approval through the city from the period of time when the 100% preliminary plans were accepted by the board in September through March, which was the deadline, which is the deadline that is in the lease amendment. Premier provided documentation of that process. That process was reviewed by Seth Bain with Lewis Longman and Walker, and he is here today, and he will address the board shortly with some information regarding his review. And the second condition that the board imposed was that we prepare an amendment that would allow for that requested 6-month extension with certain changes made to the default provisions contained within the language of the lease. That amendment was drafted by legal counsel, reviewed by airport management. It was presented to Premier. However, Premier rejected the 11th Amendment as was written. Subsequent to the preparation of the agenda item and the resolution that you referenced, Mr. Chair, this past Monday, I think it was, we received an additional request from Premier to negotiate some economic terms that they believe would be beneficial in their mind to the airport authority relative to the construction deadline that is contained within the lease of August 2023. So the request, as I understand it, and folks from Premier are here today, can speak directly to what they're currently requesting. The request, as I understand it, is to table this action again with regard to the deadlines that have not been met, the last deadline being March, and that would allow them time to present to us what they would like to request again in an 11th Amendment. And before I turn it over to Premier, I would like to introduce the team. Of course, you see Amy is back with us, so happy that she's here. And of course, Janice, who's been guiding us in her absence. We also have Seth Bain, who will address the board shortly. And joining us via Zoom is Peter Kirsch with the firm of Kaplan, Kirsch & Rockwell. He is on the team, has been on the team since the engagement was entered into with Louis Longman since December, I believe, 2016, I think, if I have that year right. And they represent us and provide us guidance and counsel relative to federal FAA matters, as well as the aviation side of our business. So Peter is joining us via Zoom today. So with that, I'd like to turn it over to Seth Bain to address his review and the context for his review of the permitting process as was presented by Premier.
Good afternoon. As I said, my name is Seth Bain. I'm an attorney with Louis Longman & Walker. I'm also a certified land planner. I have a master's degree in urban regional planning and began my career doing development projects, both for private and public clients. After I sent my memo in to Clara for the review, she thought it would be useful for me to just come explain exactly what I looked at and what I didn't look at in context of this project, because certainly I know there's a lot of background and history to this that I'm not that familiar with. The question as it was presented to me was that the firm of Driscoll's firm had submitted this letter on behalf of Premier, discussing what the timeframes were that they were looking at for preparation and submittal of the application, what it might look like going forward. So the question as it was presented to me was, does this look reasonable for the type and scale of development that they have going forward? As I said in my memo, the answer to that simple question is yes. If you were starting a brand new development project that you were asked to come in, prepare a set of applications for, and run it through the city for a new project, something along the time frame laid out here would be a reasonable amount of time. That question doesn't answer some of the larger questions that are out there. The letter that was submitted to us makes the point right at the outset, hey, there was a site plan that expired. I don't know the history of that. I don't know why it expired. I do know that when you have a existing vested site plan that helps you in the process, that helps shortcut some of that, having those rights there can help you in the long term. But that wasn't the question that was presented to me. So I just wanted to make that clarification today on the record. The question given to me was, are these the sorts of time frames that one experiences in today's environment development world? Yeah, sure. This is what these things typically take. That's the extent of my review. Obviously, a much larger picture here that you all are here to review and examine here today. And I'd be happy to answer any questions about what I did or didn't look at or the memo itself.
Thank you very much, and I think your letter is on page 42 and 43 of the board package. If board members want to refresh their memory. Clara, anything else? Any questions of Mr. Bain, I guess, first and foremost?
Seth, during your discovery, did you happen to speak to Bonnie Miskell at all?
I did not. I only relied on their representations, my familiarity with the city, and some review of the city's current process as it stands today, which I'm already somewhat familiar with.
All right, thank you.
Any other questions? Thank you, Mr. Bain. Clerk Clara, next.
I'd like to turn it over to Janice and Amy to discuss the 11th Amendment that was prepared, as well as sort of what is our understanding of what the current request is.
So, as you recall, Mitch made an offer at the table, willing to consider the 6-month request in exchange for changing the default provisions of the lease. And one of the things that we had discussed last week is this ability to create no apparent limit to it. So he wanted some way to tighten that up. And we had spoken with Mitch after the meeting, and we came up with the plan to accept out the requirement to get final plan and permits and to have the building from this paragraph that gives the 30-day cure period. So that was how we approached this, and that's the amendment that we provided to Premier. As I said, we provided to Premier. They did not respond back with comments in time for the meeting, in time for the meeting deadline, but they did in fact reach out that day to discuss a separate offer, not an extension, but as you see, sort of an economic remedy. So bear with that.
And is that the letter we have in front of us that was handed out today, or is that one that came earlier this week, I guess?
This is the letter the email that was circulated last year to everyone that the FAA issued us.
Oh, okay, yeah.
Regarding their concerns with the continuing number of extensions that had been granted, and their guidance to us that we needed to really hold fast to those deadlines.
Okay, yeah, I see the late, Monday, March 15th, 2021, from Miguel Martinez. Okay,
Right.
So this is background information.
Correct.
On the FAA's position, is that what you're talking about?
Correct.
Okay.
So if I may,
I think I'm with you now. Okay, keep going.
if I may, just to kind of provide a framework for the rest of the discussion, it seems to me that there are potentially two things for the board to be considering here today, one of which is just a housekeeping measure, because it has become clear to me in reviewing what has happened in my absence that a deadline was missed and that a notice of breach has not been issued. And so from a housekeeping perspective, you do want to make sure that you have correct paperwork indicating when you think a breach exists, because that creates a common understanding with respect to the initiation of the cure period. There's been discussion about the cure language and what it means and how it applies in this instance. We're not asking for you to resolve that today, but it appears to me that it would be appropriate for the board to direct staff as to whether you want to send out a notice of breach so that all the parties understand where they are with respect to that missed deadline. Now, the second issue is, there was a request for an extension of time. There has been dialogue on that. That extension of time and what it would be facilitating in terms of negotiation appears to be a moving target because of the nature of the request from the tenant. And so it appears to me that it would be appropriate for the tenant to advise you on the record here at this public meeting what it is that they would anticipate our discussions being, those discussions that would be facilitated by the extension, and then you would be able to entertain whether or not those discussions are something that you want staff to pursue. And so I don't know if this is a good time for us to now hear from the tenant about what they think they need, what they're willing to discuss with staff, like what kind of resolution they'd like to see, and then the board can consider what it thinks is in its best interest. So to me, those are the two issues. Yes, ma'am.
Is there an order of priority here? In other words, it seems to me that the breach issue should be addressed first and then followed by the other, just to put things in a framework, or am I missing something? Maybe if you were talking about notices to cure and timelines, starting when? I mean, that's when you need to have the...
Certainly. So that it seems to me that you would want to hear from the tenant and understand how all the parties would see the process moving forward, if there's going to be further negotiation or if there's not. because it may impact the content of the notice letter. But having some form of notice letter to me feels like housekeeping, what you want in it and what it contemplates, I think would be informed by what the tenant will be asking and what you are willing to entertain. So I would think that you would complete discussion and then consider the two items in tandem.
Content of item number 2, basically, the nature of the discussion would be included in the directive to you about breach.
That is what makes sense to me.
That's what I'm asking, is what is the sensible thing, timeline, order of priority, first this, then this, but you're saying the two are really combined. So the breach letter would be put into the parking lot right now, and then we would go forward and hear what has to be said.
Exactly, and then we'll circle back around and we'll understand the content of the notice, so that the notice reflects the current understanding of all the parties as to next steps.
Got it?
Okay. So I'd say we hear from Premier. Is that what we would like to do? All right. We have a representative from Premier. If you would use the podium, just because we're recording. Thank you. The microphone there. And if you would introduce yourself, that'd be great. Thank you.
Absolutely. Board members, thank you very much for this opportunity. I appreciate being here. My name is Edward Marchos. I'm with the law firm White Serta Helfman. You've heard from my partner, Howard Dulasar, at the last meeting. Unfortunately, his wife is having surgery today, so he couldn't be here. He asked me to be here instead. I'm joined by my client, the tenant, Premier, and also Ms. Laura Odom, who has been buying Ms. Lewis' office. Okay, and she can, to the extent there's any questions you have with respect to the zoning, the process, et cetera, she's prepared to answer those. But I want to hone in on what is really the key issues here. And you've already heard from your own counsel that the time frames that Bonnie's office and Lauren's put together are reasonable. Now, with respect to the idea that there has been a breach, at the moment, it's our position there has been no breach, and your counsel has said that there has not been a notice of that breach. The reason for that is because this original lease was negotiated a very long time ago, and the provisions are such that they're very favorable to my client. There's no sugarcoating it. It requires notice, and it also provides that if there's a cure that would reasonably take 30 or more days, and you're actively pursuing that cure, there is no breach. We've heard from your counsel that it's a reasonable amount of time that we've laid out to pursue that. We understand your discomfort. If the roles were reversed, we feel some discomfort, and so what we're proposing to you is to address that, as we did at the last meeting. If you want, I could read that language for you, but I think at this point you've read it a few times, you're comfortable with it. We'd like this tabling of the item to the next meeting to allow us to work out new language, and furthermore, to address this additional issue that was raised by the FAA. The FAA, as you know, raised concerns about generating income, and we think it's a fair concern. So the purpose of this, of tabling the item and allowing us to work something out, is to ensure that the airport starts receiving income as soon as possible. Okay? And so what we'd like to discuss is applying the terms that are already in the lease for rent calculation and figuring out what a reasonable, appropriate rent would be, and when it should start during the construction process. So I'm talking before we have necessarily opened. To that extent, it may make sense for the board to appoint 2 members, perhaps, and your council's nodding their heads. They're in disagreement with that. I understand. I wasn't aware you were in disagreement with that. But in that case, with staff, it'd be quite all right. And we would work with staff and come to the appropriate rent based on the formulas that are already there, and the appropriate language, a commercially reasonable default language, so that we don't come into this situation again. And that, in a nutshell, is what we're proposing for this, for this 1-month tabling.
And if I could just clarify my involuntary head nod, obviously, you're a sunshine agency. It creates difficulties with the sunshine law if you have 2 board members who would be negotiating. It's also a delegation issue. The board is not set up to allow someone to negotiate on your behalf in that way. under your enabling act, it is the executive director who negotiates, and so that is the setup.
Yeah.
It's just background.
I mean,
I understand your concerns. I mean, I had solutions to those, but I'm not gonna push. If you prefer us to speak to staff, we'll speak to staff. Quite all right.
just a point though, I mean, setting aside the sunshine, it's any business, it's just doesn't seem like it's a practical solution to say, we're gonna cut out staff, negotiate with 2 board members. I mean, so it doesn't seem to make sense
Board member.
setting aside the sunshine.
I hear you loud and clear. First of all, that proposal's off the table. Your staff, your attorney suggested no, so it's off the table. But to be clear, we were never suggesting staff to be cut out. That was not my intention.
All right, so we'll talk about negotiating with staff, so I think we've all agreed on
Exactly.
that.
All good.
Mel, yes, sir, you have questions?
You talk about, you want a month extension, table it for a month, and then are you going to be coming back to us with a plan to start paying rent until the building is finished?
My client would like to speak to that point exactly.
That's where I lost it.
Right.
And how many of you would introduce yourself for the record?
My name is Hamid Hashami, 21 Compass Isle, Fort Lauderdale, Florida. Thank you, everyone, for allowing us to present our this matter to you. What we're proposing is, if this project, we understand the issues at hand, which is you're looking to have income, generate income.
Right.
What we're proposing is that if we continue on this path, we will come up with you. We sit down with Janet and Amy and Janice, and we'll come up. I'm sorry, Clara. I apologize. And we'll come up with a plan.
Claire.
We'll start paying rent before the building opens up. I'm not saying we're gonna pay rent tomorrow, that's just not justified, but we'll be happy, and I know there's provision in the lease that we've had disagreements for a long time on calculation of percentage rent. We're happy to address that. So we're gonna come up with a solution that, assuming the building was open, you're gonna generate revenue, whether the building is open or not. This is gonna solve the problem that you have with FAA, it solves our problem. We can proceed on a normal basis. We have every intention to build this building. This land sitting there empty doesn't generate revenue. I didn't do this as a charity. This was intended to produce, we're supposed to make money with it. So we have every intention to move it forward as fast as possible.
But can that be done in a month, when we say?
Absolutely, yes.
Because we're on the 11th one or 10th, so that's been going on for a long time, so I don't know if a month is reasonable. I don't know.
Look, it's a matter,
Let's define what it is that we will see in a month.
Okay.
Yeah.
To be totally frank, both parties need to be reasonable.
Will we see an amount? Will we see a time?
Yes, both of those two.
A date and
Otherwise,
an
it's a waste of
amount.
time. We're not here to waste your
Okay.
time or our time.
All right.
I mean, frankly, I'll speak for it. From a legal standpoint, we can, if you look at it, there are provisions there. We're meeting, as far as we're concerned, we're meeting the deadline. We can continue the same path, but we don't want to go there. We'll be happy to sit down and come up with an exact amount and a time when we're gonna start paying it. But it's gonna take both sides to be reasonable. And Janet and Amy know exactly what I'm talking about. There's an issue of dispute that, we've been paying percentage rent for the last 5 years, right? Because according to the lease. There's different interpretation of the clause in the lease that, am I right or wrong? Just put it all out on the table.
You all may recall, several meetings ago now, that there was some discussion that we were interested, at one of the prior extension requests, to reopen several issues that required clarification, so that if this was going to be extended, that all the parties would be using the same math. And at that time, there was some concern on the part of Premier that we were withholding consent to the extension in exchange for asking for benefits, which was not our intent. We were wanting to clean up the language, and as it appears, that was a good desire on our part, because here we are almost a year later, and that language still needs to be cleaned up.
That is now being acknowledged. Clara Bennett, Executive Director.
So that is an issue. I would like, just because there's some question about, are they in default, not default, I feel like, it's common when we're using language for words to be as though they are the same. A breach is one thing, and a default is another thing under the contract. A breach is when you have not done what you contracted to do. And there can be no question that in this event, there was a concrete deadline that was missed. That is a breach. The breach creates the opportunity to cure, and this is where you have the language that says if you cannot cure within a certain amount of time, then you may be held to be in a material default unless, and then we're talking about this language about progress. And so I said on the record, there is a breach, and that is a correct statement of fact because a deadline that was a hard deadline was missed. Now, the default language is what we're talking about. So I just wanted to make that language issue clear.
One quick question.
Cheryl?
Is there any question on your part as to whether you are in breach by missing a hard deadline? Thank you.
Two questions. First, so part of this 30-day time period we'd also be addressing the ambiguity and lack of clarity that was pointed out last month that Mitch, had brought up about the, default and the cure. We'd be addressing that as part of this as well?
That was the suggestion of the board, and if the board brings that forward as part of the negotiation, that would be what staff would act on.
So, and then just, if I may, the second part, and I don't know when the appropriate time to ask this, but Hamid alluded to, doing this would satisfy the FAA. A lot of us expressed concerns about that last month. I guess the question is, does it, will it, how can we say that for certain?
Mr. Kirsch is here, and he is really the best person to answer that question, I think.
If I may interrupt for a second, I need to clarify something on the record.
Okay.
I'm sorry, sir.
Yes.
Remember, but your question again was, repeat your question for me, please.
My question is, do you agree with the statement that was just provided by our counsel saying that it is a statement of fact that you are in breach?
And my answer is no, we are not in breach, no, we are not in default. That's our position.
Well, we understand that you are not in default, going by the guidelines that were just articulated, I thought, very clearly and simply for those of us who are simple on this end of the table. But a date's a date, it was missed, and if we can't, here's my concern, ladies and gentlemen, we can't even agree with the client as to whether they are in breach. How do we go forward? Give us some scenario that gives us confidence that in 30 days, when you don't even agree that we're in breach, that we are going to negotiate a formula that is satisfactory to both parties when we have not done that in a year. We want to get there, but we can't even agree at the beginning that you're in breach. And we have at least probably 3 counsel at this table that will say there is no question. Here's the contract. Here's the date. They missed it. Okay, we're not even saying we're going to give you a breach letter yet. That's what we said. Let's see what the whole thing looks like. And you talk about reasonability. I don't even see the beginning of the race. I don't even see where the start line is. You don't even get the start line.
What is reasonable, beyond reasonable, what is gratuitous on our part, is that we're offering to begin payment to you before we are receiving any revenue.
I understand that. And I agree that I think that in itself is a starter. But what is a non-starter is if conceptually we don't agree that there is a breach, and then payment could start at 1 penny, because that might be your version of reality here. Let me just finish. Above what the current formula is. That's one step toward the end game. And I want to get to the end game. We all want to get to the end game. So please, so we can get out of this. But I don't see that we have a framework for that yet. So tell me where I'm amiss, please. How do we go forward if we don't even agree that there has been agreed?
Yeah.
Right, and I interrupted a question that was asked of your FAA expert, so.
Well, but
So-
it sounds like you've got a threshold issue that you want to see if you can have a meeting of the minds. I mean, to me, what I have heard from Premier is that they are relying on the cure language in the default provision for saying that if the cure cannot be effected within 30 days, then progress is what you rely on. Now, you would not need to think about cure language if you did not miss something.
Exactly.
And missing something is simply a matter of looking at the calendar.
Comes after breach.
So that's why I said it's a simple fact that they owed us something in March. They did not give that to us.
Right.
That is the thing that opens the discussion of whether or not they are in a cure period, that they are meeting their cure obligations. So that is why I have said there is a difference between breach and default. And so I think that your comments are well taken, that it's difficult to understand what the table is we're going to be meeting on if we don't have an understanding of even that much of how the lease.
With that as background, I didn't mean to cut off our counsel, who was answering someone's question.
Peter, I think the question was, what do we anticipate, I think you're probably the most well-equipped person to try to anticipate that.
Thank you. This is Peter Kirsch with the law firm of Kaplan, Kirsch and Rockwell. I apologize for the noise in the background, but I'm at an airport. I need to be very careful what I say in public session because it's not my habit to give legal advice in public, and for reasons that are pretty obvious. A couple of points are important here. Number one, that the authority is obligated to secure fair market value rent for property that is being rented or used for non-aeronautical purposes. That's one of the FAA's concerns, and we have to show that we are receiving that. Now, the FAA does allow for, I will call it a waiver or a forgiveness of that requirement during what's called a pioneering period. During the period, usually very short, when a tenant is finishing construction, doing construction of their project. And that's usually measured in a couple of months, maybe as long as a year from when the lease begins. So there's a second, so that's that from the perspective of where we are on this particular lease, that's problematic. The second issue is that the FAA prohibits what's called land banking. And that is when a tenant holds on to land for a period of time and has not developed it. That is an impermissible use of airport land because what it does is it precludes someone else from leasing that property and providing fair market value. Now, one way to demonstrate that there hasn't been land banking is for the authority to receive fair market value for the property. Another way, of course, is to build something and get rent on that. With both of those particular problems are present in the current case, and I think the FAA has, at least from my experience, been extraordinarily patient. I think I can probably say without fear of contradiction, I've never seen them this patient with a project for a whole bunch of reasons that I won't go into in public session. But it's important to recognize that the authority does have obligations, both with respect to fair market value and with respect to avoiding land banking that could easily be triggered, frankly, at any time by the agency.
I just want to be sure I understood that correctly, if I may. That what we are hearing is that looking at the facts, the history here between our two organizations and this particular piece of land, that it is possible that some third party looking at it on behalf of the FAA or the FAA, meaning the second party, could say, that looks a lot like land banking.
Yes, that's correct. And that would be a decision the FAA would make. And if they made that decision, they would return to the authority for an explanation or a remedy, what they call a corrective action plan, to make sure that you are correcting the land banking, if that indeed is what's going on. And as I say, the situation here is exacerbated because not only has the tenant held on to this piece of property for a long period of time without development, but the authority has not been receiving fair market value for the property during what amounts to a substantial period of time. And we can disagree as to what is substantial or not, but it's clear from the FAA correspondence that their patience is what do I want to say? Their patience is running to its end.
So just, nobody likes to hear the word corrective action. I mean, that always kind of comes across as being negative to me. A question being, I lost my train of thought. The FAA's interpretation of that, could that hurt us in other areas? Namely, our grant, what we're doing from a grant perspective, which I think we all feel we've got a great relationship, based on our ability to deliver.
Well, without making light of your question, there's the old expression, he who has the gold makes the rules. And the FAA is not above finding ways to limit discretionary grants, not give discretionary grants, not be cooperative on matters where authority staff may be seeking waivers or permissions or forgiveness. The FAA can and does make it clear to airports that if they believe that the airport is not adhering to FAA requirements, that they can use their leverage. That's just natural, and they do that all the time.
Yes, sir. I want to address a couple points. First of all, the concern over land banking. Land bankers do not apply for permits, do not work on amendments to their leases, do not work actively to develop a site. And that's what we have been doing. That's what we're committing to you to continue to do. Some of your council has commented already on applications that have been filed and are in process. Furthermore, with respect to revenue, if fair market value is what's required in order to satisfy the FAA, we can talk about what fair market value would be for the project that has nothing on it and is not creating any revenue. We're willing to be generous here and even potentially exceed what fair market value may be for the FAA. But that's something we're not going to find out and confirm the amount of, frankly, today. It's something that we need to discuss with your staff and work out. And we're trying to be, frankly, generous here, and we need that time just for that purpose. Board member Folden had asked whether you would have a dollar amount and a time, right? That's, at the end of the day, those are the two things you need from us. My client has committed yes. I'm here to repeat that commitment. I think both of those commitments, when we deliver next month on both of those, frankly, would address any idea of land banking. Someone doesn't pay money if they're land banking, pay rent, or pursue permits. And certainly, you will be generating revenue. The thing we need to calculate is what that revenue is, what that dollar amount is. That's what we need to work out.
Okay, Cheryl?
Question of council, please. What happens in the scenario that we say, okay, let's go forward and give this a twirl? After all, we're in for dime, in for dollars. Like this is just we issue another 30 days, won't kill us. But at the end of that period, we are kind of where we have been before on the issue of reasonableness. We just can't seem to meet in the middle. The middle can't be found. So we come up with a stalemate, and then we say, hey, they weren't reasonable. They say, hey, we weren't reasonable. I see that as a likely outcome, given our past. Hopefully not, but certainly something we need to consider. And my question is, what then?
But there are third parties that can help us establish the fair market value, right? So
we've kind of done that, haven't we?
Well, so what was just said by council is something that I've heard for the first time, and I think that, we would need to have an understanding of the board's expectation, because there was discussion of fair market value based on unimproved land. I don't think that's the benefit of the bargain that the lease contemplates. And if you're talking about payments that are from the date of construction, when that date is blown, as they've told us it will be, to the date that the building is actually built, the benefit of the bargain isn't fair market value on undeveloped land.
Right, I thought I'd misheard, actually. I was hoping I did, and that you would.
I don't think you did.
Okay.
And I don't think it's generous on the part of the
Yeah.
tenant to pay you the benefit of the bargain when they blow a deadline.
So,
So you really get into a situation of a fight over what they're entitled to do in the cure period. And, you know, your legal remedies at that point are what's available under the contract, which, you know, may not.
cure period isn't really a cure period until they've been notified of breach.
Well, and that's the situation. I think that if the board wants to take the position that a blown deadline is a breach, under the theories that we've been discussing here, then a notice to make it clear it has not been waived and that these discussions that you're contemplating entering into does not constitute a waiver or an exception to the blown deadline. I think that, you know, making that record clear is appropriate, and that doesn't prevent you from having the discussions that are being suggested by the tenant.
May I have a follow-up question?
Yes, ma'am?
So is there, let's assume that we say, well, we still want to give this a twirl, you know, we still want to go to the dance party. If we give direction, though, to go ahead with the notice of breach, would you anticipate that it happen now or still wait the 30 days, and assuming that we come back with something, which I don't think we will? Hopeful, yes, but do I think so? I'm not so sure. If we can't decide, we haven't decided what it is yet now. You know, is it on developed land? Is it anticipating development and what you would have gotten if it was developed? Those are two vastly different. And then on top of that, you've got the reasonableness, you know, highest and best use, and we've been down that road before, had an outside consultant come in, and we couldn't agree on that. But my question, to be real specific, is if we go the route of saying we believe that there is a breach, I understand you may not believe there is a breach, but we have three people who say they are in trusted counsel, I believe that it probably is. Is there a major problem with that? Does that impact negatively Hamid and his group at all, that they have been? It's like, oh my gosh, and that means that we have to pay fines or something like that. So that is really not the intention here. From my perspective, the intention is to cross our T's and dot our I's. I don't want to be 6 months, a year down the road, and you never even told us we were in breach. So our clock hasn't started to tick yet. So I think we all know that we present the airport authority board, that's our first fiduciary responsibility, and but at the same time, we just want to be cognizant of what that means. Is there anything majorly negative impact upon Hamid and his group if you're in breach? You're in breach, just means the clock has started, and now we're going to start here. That's my understanding. It's simplistic, but that's my understanding.
So I can tell you under the contract, whether the contract provides for a negative outcome to the tenant in the event of a notice of breach. I cannot tell you whether there are collateral consequences for having received a notice of breach on relationships with anyone else, because that's not something I've evaluated.
I understand that. If that's what it is, that's just what it is. There's nothing else in the contract that would have penalties or anything.
Yeah, I mean, so the way the contract is set up, that default provision is if you become aware of a breach, then you notify the tenant, and then the tenant is able to initiate a cure period. What the cure period is with respect to this particular breach is the live issue, but acknowledging that you are in a cure period rather than in a pre-breach period, I think is appropriate and important to maintaining your full
protecting our interests and timelines and
full ability to exercise rights and remedies, because it's been discussed now a couple of times, and if you don't assert that you perceive it as a breach, then you don't want for an independent reviewer of this whole process to even tell them it was a breach. You waived it because you knew it, you never did, and you didn't do anything.
I know there was a problem.
The crux of the issue, right?
And if I may, that was the action that was tabled last week, last month, when the 6-month extension, that was requested. That was the action, because the reason for the 6-month extension was because there was an acknowledgement that a timeline had been missed. Otherwise, there would not have been a need for a 4-month that became a 6-month extension. That's why. So that's what was tabled, was that notice that they had missed the deadline, so to allow us time to negotiate the amendment that was presented, that then was rejected. So now they're asking us to table it yet again. That's again, it is a tabling that is being requested of that specific action in order for them to present this, what they believe is this economic benefit that they purport we will benefit from if we were to grant another amendment. So the tabling is the salient thing.
Right.
Tabling of this notice of breach.
Both parties want to negotiate these issues, the rent and the time to cure issues. The question is, do we table it and try to do something, or should we declare the breach? We've already tabled once.
Right,
correct?
because if they had not
So
needed
that's what we're looking-
if there was no need to extend, then they wouldn't have requested it. If that deadline was a loose
Yeah.
deadline, they would not have requested an extension last month.
And the cure period allows for negotiations, correct, after?
Now,
If we allow that.
Okay.
now, if the tenant wants to be on record here telling you that they acknowledge that you have not waived any rights by entering this negotiation period and not issuing a notice of breach, and the board can entertain that, but that's not what I've heard today. What I've heard today is that they don't believe that they are in breach. And so,
That's not gonna change.
it's, to me, I mean, you protect your, your
Yeah.
status of not having waived a breach, either by issuing the notice of breach or either by receiving something from the tenant acknowledging you haven't waived your right to
Lacking
allege this is.
hearing that, I think we need to follow council's, our council's recommendation.
Board members, I think we can help you with that.
Okay.
If what it'll take to get to a negotiation table and work out all these issues over the next 30 days is an acknowledgement that you have not waived any rights by failing to give us a breach letter, my client just notified me he's willing to give you that. I want to add just one point, which is we have been actively pursuing these applications. Part of the reason why the 6 months extension didn't go through is because of permitting issues that we had. And so a 6-month extension, the permitting process that could never be done in 6 months was sort of futile. And that's why we're not talking 6 months. But right now, if you need a 30-day, if you need an acknowledgement that there's not been any prejudice to your authority as a result of no breach letter, we are putting that on the record right now. And we're asking that you please allow us these extra 30 days to negotiate with your staff.
And we're not asking for you to give us a 6-month extension.
We're not asking
So
for that right now.
You
right?
don't have to give it to us, so we're not working under any assumption that you're giving us anything.
Correct, correct. I just needed to clear that point.
Verbal adequate?
I personally would request the attorney to follow that up in writing, because, these tenant, relationships are long and memories are short, so I think it's valuable to have it in writing, but certainly if council's making a representation that he'll.
It could be such that anticipating the receipt.
Then you can have that.
Then blah, blah, blah.
You can have that as an option to consider, and it's the board's prerogative.
So it's either that or call it a breach, I guess. We could take their written commentary. So again, Cheryl, and then go to Eugene.
I'm
Cheryl.
sorry, just one more follow-up.
Yeah.
Does staff and council have a reasonable expectation that in 30 days we will come to conclusion?
So I will tell you, most of my work is done in litigation, and I have seen cases settle where people absolutely despised each other, and then I've seen things where it seemed like you should be able to meet in the middle, and then they don't. So I never say never. In terms of workload, I can make myself available at Claire's direction to work through things, but I am aware, of course, that we've been having these discussions since you hired me in 2016.
And that's what I wasn't so much the.
There's that.
We have not had sit down and discussion.
And to answer from my perspective, Ms. Bud, I think we've had challenges to date, as evidenced by some of the conversation here, in even agreeing as to facts. So it's very difficult for me to answer that question as to whether 30 days is sufficient.
We still don't even know if we're talking about undeveloped land, developed land.
Right.
Even
just facts
You've got a lot of things to figure out, so.
Gene, did you?
Yeah, just a point of clarification. It's my understanding that they are in breach when they receive a breach letter from us, and they have 30 days to cure, correct?
Correct.
Okay, so if next month we find that they have not met, are you prepared to issue a breach letter at that time?
If that's the direction, I can absolutely have it
And they
ready.
would then have 30 days or another 30 days in which to cure, okay? I just want to make sure that we get the letter and the timing and everything.
Good point. Good point.
Bud's
Careful.
need here.
Good point.
Randy?
You know, back to the 30 days, I mean, again, is it reasonable, particularly, setting aside the history of anything, is it reasonable to assume that we can get this accomplished when we're gonna have to pull in third parties and do back and forth and get number crunchers involved in everything? I mean, is it reasonable, again, setting aside the history and the skepticism?
It may be that we can agree on a superstructure that requires input of appraisers and so forth, and we can bring you back something that's, that's built out as a framework, in which case, we could ask for further direction, or we may come back and say the conversations that we've been having historically remain in the same place. So, I don't want to string this out forever, but I also, I don't want to foreclose conversations that are beneficial to both parties.
Absolutely, and I think there are some core questions you'd start with before you get to how many dollars and cents, like developed, undeveloped. Yeah, so there's, you get those, you can't get past those. We don't need to bring in the outside people to tell us what's highest and best use and reasonable if you can't figure out.
And certainly from staff perspective, this is our highest priority at this moment because we recognize that time is of the essence, and for both sides of the negotiating table. So I have no plans to go away or do anything other than focus on this between now and then.
I'm happy to commit to, and I think frankly it's the best way of doing it, just set the emotions aside and the differences aside, let's hire a mediator.
Well, that's a whole new track.
Yeah.
No, I'm suggesting, you don't want to do it, you don't have to do it, but I wanted to tell you,
That's sort of the issue.
I'm happy to consider and negotiate this thing. If it helps to have somebody in between us to negotiate this, I'm happy to do that.
To me, a mediator is valuable when you have litigation because you have a set of allegations, and the question is one person is right and one person is wrong. In this instance, the authority is constrained by certain requirements of the FAA and certain, obligations to the public trust in terms of your, working in the benefit of the public in the operation of the airport. But, I don't want to speak for Director Bennett, but I feel like I can in this instance. From our perspective, there is no emotion on our side of it. It's more of just, there are things that can be done, and then there are business decisions that each party has to make as to what is in their best interest. And sometimes you can make those align, and then sometimes you can't. A mediator couldn't, for example, tell Mr. Hashemi that, the right answer is for him to agree to a certain business term. That's not something a mediator could do. Whereas in litigation, a mediator can come and say, your case isn't very good. So for me, I don't know that I think that's probably your go-to move at this juncture, but, whatever you would consider as forward progress, I'm willing to participate in as your counsel.
Gene?
If we're going to be putting together a letter, a motion here of understanding, going back to last month's meeting, one of the major concerns was that what was the time element were they meeting their need as we saw it, as far as filing their permits and following up and doing all that. Based upon that, I would like to enter into the agreement or the understanding, motion, whatever, that they notify us in a timely manner of any actions between Premier and any government entity that would occur. And that would include, but not limited to, applications, approvals, submissions, resubmittals, comments, denials, scheduled meetings, and hearings. And I'd like, so that we are, on, in line with exactly what they're doing, when they're doing it, and how they're doing it. And as well as any action or activity that relates to the site itself. Also, I would like to see that we enter into an understanding that there'll be a time element from the time they get their permits to the time they start construction. I'd like to see that to be no more than 45 days. In other words, they are to break ground within a given period of time from the time that they get their final approval from the city.
I mean, did you comment
Yeah,
about all that?
providing you information, I think we're already doing it, and we're happy to put it in writing. I think Ms. Odom over there, I mean, we submitted last week, or sometime this week, with the latest comments that came from the city, and I think your council has that.
Good evening, Laura, I'm doing this one back. To follow up, yes, we have been actively providing updates on the project. Actually, in the middle of last week, we were issued additional comments trying to prove it. I'm really working on resolving, and I have a copy of the comments here for everyone's reference. And we'll engage.
Ms. Odom, to whom did you submit that? Because I don't recall a copy of it to us.
I didn't forward anything as these were released in the last week.
Oh, I see, okay. I misunderstood. Thank you for that.
Perhaps or not, if you guys would like to do.
Yeah, we have been actively providing updates.
No, the last communication I got was what was received a week after the last board meeting, which is in the board packet.
So, the previous resubmittal, was what was provided, the comments that you received actually, on the day of the meeting, I believe it was the day of the last meeting.
Correct.
From that, it took about 2.5 weeks to get everything together, resubmit, and I believe we said in the email to you that we had resubmitted. I'd have to go back and double check, but I'm 99% sure we did. After that, we received comments late last week, middle to late last week, and these are the current comments we are currently working on. There's Palm Beach County that we're working to resolve. Hopefully our traffic engineer can work through those. It's a vested rights issue with previous and current approvals. So hopefully we'll get that quickly and resubmit within the next few weeks.
And I'm sorry, just for my notes, did you say it's a Palm Beach County issue or a city issue, the transportation concern that you're addressing?
Transportation is a county issue. So county has a threshold issue. We're working with them on the vested right determination. Based on that determination, we'll determine the source of our traffic study and where certain trips are coming from.
Yeah.
And we asked our traffic engineer.
Ms. Odom, would you mind speaking into the microphone? This is a recording. Thank you.
Record, please, yeah.
So it's actually, it's a county threshold issue. We have to determine whether there are vested rights. If the county determines there are not vested rights, then it determines a different trajectory of our traffic study. If the county agrees there are vested rights, then it'll make our traffic study approach a little bit easier. And then the last thing is that we resolve outstanding comments and land development comments. Environmental has assets in the community to ensure that the trees that are development are approved by the CAB board. Everything else is just traffic related. And the traffic comments, I think,
Thank you very much. Thanks for the clarification. All right, so I think we're at a stage, unless anybody else has other questions for the Premier, before we get to the instructions to staff, the motion is either gonna be, I guess, either declare breach and give time for cure, or based on the written assurances from, Premier, that, that we could table the matter based on their written assurances within the next day of, that.
Non-waiver.
Let's call it that.
Non-waiver.
Non-waiver of rights, I guess. So, anybody want to make a motion on that part before we get to instructions of staff? We got Gene's issues, we got the issues of cure, and we got the issues of the rent calculation. Based on my count, there may be some other things as well.
Should this all be in one motion, or?
Thinking, can we do,
Can't be in one motion,
can we do the issue about the
The
breach? So based upon receipt of a non-waiver letter, based upon that, we then agree to,
Table,
give him 30 days.
issue for 30 days.
yes,
Yes.
and to authorize
For negotiation.
negotiation.
Well, and for clarity, so you would table consideration of issuing the notice of breach until your next regularly scheduled meeting.
Yes.
Is that right?
Yes.
The next regularly scheduled meeting.
Now,
Contingent upon receipt of the notice of non-waiver from
my
council.
question would be, in that same motion, do we need to say that during that 30 days, you will begin
We can put that in there, sure.
conversations and negotiations?
I mean, I think
Does
that,
that need to be separate, or?
Related to the rent calculation and the cure.
so you can make your tabling of the notice contingent upon certain negotiation factors, or you can decide it as a threshold matter and then separately vote on any special direction that you want to give to a staff in having the conversations that you are contemplating. So,
I mean-
to me, you can do it separately or together.
I think the breach is a pretty important thing, so maybe doing it separately makes more sense.
So we go for the letter.
Right, what did Cheryl, that was Cheryl's motion, I mean.
I'll second that.
Was that your motion, Cheryl? I just
It
wanna make
was,
sure.
I'm still not clear on, do we have to have in this motion, or can we have separately what needs to transpire during the 30 days?
Well, I mean, as
Doing 30 days.
the mover, you may not want to agree to table the notice unless certain things are brought to
That's
the
what
table.
I'm trying to get at, that's what
Okay.
I'm trying to get at.
Okay.
And do we need to articulate what they are in this motion? Or is there some nebulous way to say, address issues of pricing?
Well, we really have the same issues from the last meeting.
I know.
Yeah.
I know, it's like.
So
you
we
did
might be able to
the whole thing,
take
and you've got
wording
the
from
things
the
you
last
want to
motion.
put in there,
Exactly
too.
right. Circle of life.
That's exactly where we're going.
Let me
Is that
ask
right?
this, can council, propose for us a motion that would satisfy where you think we are trying to go?
Okay, so just based on the notes I've been taking, and you've seen I've been typing as the conversation has been going on, what I have heard so far from the board is that you're willing to entertain a motion where you would table the issuance of a notice of breach contingent upon receipt of a letter acknowledging non-waiver in order to facilitate negotiations with Premier between now and the next regularly scheduled board meeting, and those negotiations would consider at minimum the issue of payment consistent with our obligations for both fair market value and to avoid the concern about land banking, and timing of the ultimate construction of the building, because the one does not replace the other. And then additionally, Mr. Folden has indicated that he wants for us to negotiate notification of any actions with other agencies, including approval submittals, denial, scheduled meetings and hearings, as well as an obligation that from the date that the permit is issued, that there would be an amount of time within which they would break ground. To commence construction.
Not to exceed 45 days.
And you had indicated no more than 45 days.
So moved.
Okay.
Say it back to me, Cheryl.
Yeah. Can you
You're all
please
right.
tell us?
We have,
I like this.
I need a second.
Second.
Okay, and Gene, second. Any other discussion then?
Oh, I like it.
Yeah, I
Good.
like it. Okay.
So did we include in that language addressing the default and the cure, that was?
The non-waiver issue.
Yeah, the non-waiver.
Well,
Right.
but not the issue of addressing it in the contract language, and I think that's a good amendment if you're moving to amend the motion to add a change to the lease language involving issues of breach to make it clear how
Yes.
the language applies in the construction setting. I think that's a.
Because that was one of the issues that we went away with last month,
Last
so.
month, exactly.
Right.
Yeah,
Mitch.
so,
So if
Gonna
you're going to
include-
amend the motion.
Yes.
Is that all right with Eugene as the second?
yes, sir.
Okay, good catch on that. Any other questions, any other debate? Okay, all in favor, say aye.
Aye.
Any opposed? Okay, approved. Thank you, best wishes to you, thank you.
Thank you, guys.
You guys
We'll
in
go
the
to-
restaurant, right?
Oh, you're up next, yes.
I think your issue is next.
You're good.
Just
Yeah.
stay right there, just, Scott,
Don't move.
yeah.
More fun issue.
We all could use
Something we can sink our teeth into.
Yeah.
Consent to sublease to La Condesa Mexican Restaurant, doing business with La Condesa Mexican Kitchen. So we have a resolution before us in our package, 4622, the Boca Raton Airport Authority consenting to Premier Aviation and Boca Raton's agreement to sublease with La Condesa Mexican Restaurant. So, Ms. Bennett, you want to introduce, or we'll just go
It'll
right?
be Mr. Colpett presenting.
Scott? Thank you.
Thank you, Mr. Chair. I think you pretty much summed it up already. A couple of other points that are included in the memo, just to make note of, is it's for a term of 10 years with 2 5-year renewals. The lease does require this body's consent, and it does say that it shall not be unreasonably withheld. The use as a Mexican restaurant does fit the approved uses for that portion of the building on Phase 2. As you said, the Resolution 040622 is the board, or staff's recommendation that the board approves said motion consenting to the sublease between Premier Aviation Boca Raton LLC and La Condesa Mexican Restaurant LLC. And with that, I shall turn it over to Mr. Hashimi.
I can just make one comment about the term. I just want to point out, based on the conversation on the last item, there was one provision in the term language at section number 5 at the bottom of page 6. In no event will the lease term exceed the term of the master lease. So, which is September 2050 unless terminated sooner. So in the event that you find the tenant in default and the master lease is terminated, then the lease will also terminate.
Sublease terminate at the same time, gotcha.
Okay. Quick question. So I've never heard of this. Is this a national brand? Is this a local mom and pop? Where are they?
It's a local mom and pop that's been in business for a long time here in Lucy.
Okay, so they're moving a location, or they're creating a second?
They're opening Vero Beach and Old Beach.
All right.
And this is a restaurant, really solid, value-oriented, it's a family operation.
And so obviously it's been successful in those other 2 locations, and they're moving. The question, of course, is, Tilted Kilt was there a long time, and the other restaurant was only there 2 months. The property sat vacant for 2 years?
Yes.
On a highly visible stretch of land. So what makes you feel confident that this will be a successful endeavor?
I think the fact that the value proposition is very different than, most other restaurants. The reason that location from a restaurant destination, if you think about restaurants that look for exposure on 95.
Yeah.
And, the brands that are out there, Cracker Barrel, for example. It's a destination. People will drive and will get out to it. Why do you go to Cracker Barrel? It's not because it's got a $20 steak. It's a value proposition that you go in there. This is the same concept. I mean, I don't know if you've been, if I was to compare this restaurant to something that's around here, there's a concept called La Bamba. There's one in Deerfield, it's Fort Lauderdale. Yeah. Again, it's great quality food, reasonable prices, all day long. And that's what this concept is. I've visited a couple times, just to make sure that it's good. And, things that really gave me comfort is that, most restaurants, they're putting up a deposit. They're putting 3 months of deposit up front. They're spending money in this place. They were there yesterday going through the kitchen. And again, sometimes you shake hands with someone, you know that they're doing the right thing. This is a company that, it's a husband and wife that, and their kids that are, they put their life into it.
What's the plan? What's the reopening date, and how?
They've committed to opening in 60 days, which is fast, frankly.
Wow.
Yeah, and they have penalties in the lease, which, they can cure if it's not open in 60 days, but they're moving fast. I mean, I kept them, I'm holding their feet to the fire on deliveries and making sure that it's done. menu, I encourage you to go try the restaurant, it's really good. I have to say, it's, I mean, that restaurant in Port St. Lucie, it doesn't have the visibility that this one has. It did $6.5 million last year, which is
Wow.
huge. I mean,
In the middle of a pandemic?
Yes. I mean, that's what I'm saying. It was like, I was blown away. I have their financial statement, I have 3-year tax returns, so I did my homework on them, and I'm thrilled that finally, it's finally getting leased.
We can all use a margarita right now, right?
Yeah.
I motion to approve.
Second.
Thank you.
Mel, we'll get you down to second. Any other questions? All in favor, say aye.
Aye.
Any opposed?
See?
Congratulations, good luck with that.
Thank you.
Carried away.
Okay, we have another item here, Executive Director and Staff Report. Presentation from Brick.
Thank you, Mr. Chair. I apologize, I was at a side-by here discussing the menu options, right?
Margarita is a special.
It is happy hour.
Guacamole is fresh, I'm in.
Meeting.
I would like to introduce Ms. Gianna Patinelli. She is the Director of Communications with CP Group, representing the Boca Raton Innovation Campus. And also representing BRIC is John Kay with Kay Communications. We've had some conversations over the last few months about some of the plans for the campus. They're very exciting. We also have some concerns that we've communicated as well regarding overflight issues, et cetera, with the residential component. So I certainly appreciate their willingness to come and meet with us, present you the very exciting concept, but also their willingness to enter into conversation regarding some of those noise concerns that have been expressed to them by our team. So, thank you.
Okay, Gianna, it's all yours.
Thank you, and thank you for the great pronunciation of my last name. I appreciate it. Thank you guys all for your time. It's great to be here. Show of hands, how many of you are familiar with BRIC outside of it just being across the street? Perfect, much easier. So I'm going to flip through this rather quickly. Please interrupt me if you have any questions, and I will keep to the time. So, Boca Raton Innovation Campus was formerly the IBM Research and Development Headquarters, designed by Marcel Boyer, the inventor of brutalist architecture. The campus is 1.7 million square feet of office space, and IBM and Boyer were well ahead of their time in terms of building out infrastructure that could withstand Category 5 hurricanes, incredibly durable, and has also been an iconic structure in Boca Raton. We are the largest single office facility in the state. We have miles of common area corridor. Birthplace of the first personal computer. This is also where arguably the greatest business deal of all time took place. Bill Gates came to campus and decided to license his operating system to IBM rather than sell it, arguably making him, the richest man in the universe. This unfortunately is now, the space that he did this deal is unfortunately now a tenant mailroom, but hopefully one day we can get it back and make it a museum. It's also the birthplace of the Control-Alt-Delete keyboard combination, the first smartphone, and they also did a lot of development with robotics. When IBM left Boca Raton in the early 90s, the campus was largely vacant. Over 800,000 square feet of vacant space. It was dilapidated. It became a multi-tenant office building, changed hands several times, changed names several times, and there was really no connection with the community outside of its historic past. In terms of infrastructure and durability, like I alluded to, we have a 10-megawatt generator on campus that can keep all 1 million square feet of office space running for almost 2 weeks without refueling. So for mission-critical tenants who need to make sure that their operations are running no matter what disaster, this is very ideal for them. The entire campus, the roof is all constructed with cement. So in a hurricane, there's really nowhere else you want to be in South Florida. We are conveniently located between 2 I-95 exits. We are adjacent to a tri-rail shuttle, and we have a private shuttle that has 10 stops around campus. It takes people to and from Spira, and we have triple redundant, high-speed fiber. When my company, CP Group, acquired the campus in 2018, we had the vision of taking that history and bringing it into the future so that this could continue to be a place where innovation thrives. So we have begun to put the building blocks in place there with a quality tenant mix. When we acquired the building, it was only 66% leased, and it had remained back office tenants, data centers, and we have slowly tried to retain a more quality tenant mix, and today we are 90% leased, which the building has not been 90% leased since IBM was on campus. We rebranded the campus as BRIC, or Boca Raton Innovation Campus. We're bringing forward Google Campus type amenities that we hope will not only service the tenants on campus, but also the community. This is a snapshot of the tenants that we have on campus today: 18 national, 19 regional, and 7 of the top 100 employers in Palm Beach County. Our most recent tenant is Boca Regional Hospital. We also have Canon, Modernizing Medicine, Blue Green Vacations, and some other, our focus is primarily on technology and life sciences. So on campus, we are building out what we consider an amenity corridor, kind of anchored by 2 coffee shops. Marcel Brewers, named after Marcel Breuer, and you have his face on the wall, his quotes. If you haven't been to campus, or if you would like to take a tour, please let me know. We would love to have you. And then this coffee shop is Java, named after JavaScript. We like to be punny with everything we do. We want to have Boca Raton's first food hall that will be called Bite, in the IBM logo font, BYTE. We have a dining hall that will continue to be a dining hall by day, but could serve as a presentation hall and event space at night that can seat up to 1,000. Plan to have a wellness center with an on-site nurse, bike storage, a STEAM lab, and a courtyard that could serve as outdoor space. We currently already have the fitness center and the conference center that we've hosted a bunch of programming in. We are currently in the process of breaking through the building and have already gotten site plan approval on that. So this is going to create an inner ring road that makes it a little bit more accessible to get throughout the campus, but will also serve as a front door. If you've been to the campus before, you may have not known that you were in the right place. And so when IBM, this is intentional, when IBM was on campus, they didn't want anyone there. As it became a multi-tenant office building, and even today, we have 13 different addresses on campus, and when you're visiting, you're going to the tenant space or the entrance that makes most sense for that. But as we really aim to be a destination for the community, we needed a main entrance, so we will be developing a porte cochere with drop-off, valet, concierge, and so hopefully this ensures you never get lost again. I am going to show a quick video of the amenity corridor that will kind of walk you through a virtual rendition of what you could see on campus one day. So taking it one step forward, outside of the amenities that we have planned on campus, the property is on 123 acres. We are 1.7 million square feet of office space, and we have 5,000 surface level parking spots that essentially serve as a moat around campus. So we have the vision for building on top of that parking lot to create additional uses. Our existing zoning has not been updated since the 1960s when IBM was here. It is currently only zoned as a single office commercial use. So any amenities that we build on campus, any events that we have, the food hall, the event space, and hopefully one day the additional uses, none of that can be available to the public or the community. It is only something that we can market and provide to our tenants in the existing building. So we are office landlords and operators. We are looking to improve the office conditions and help grow the office campus. We have been fairly successful at bringing quality tenant mix to the campus, but we still have a long way to go. And we hope to one day compete with Silicon Valley in Silicon Beach concept, which was the concept that IBM really had spearheaded in its day and was unfortunately, due to Florida exports on taxes on exports, that is why they ultimately left Boca Raton. So in addition to amenities, if the pandemic has taught us anything, it's that employees want access. If employers are going to attract and retain quality talent, they need to provide a true ecosystem that's going to make it convenient and easy for them to go to the office. So this concept of a 15-minute city where you can walk outside your door, go to the office, go home to walk the dog or eat lunch, go to a restaurant, go to a networking event, all without having to get into your car. Employees also want community, so taking a page from Amazon in their new HQ2 in Virginia, they'll have 3 office towers, but they're also adding a retail component, childcare, a community center, and they've created this spiraling mountain, kind of as a draw for the community to really bring the community in. So these types of tech and life sciences companies that we're looking to attract, we're trying to provide that and be able to provide that opportunity in Boca Raton. So this is conceptually what we are looking to do with BRAA. You will see the existing 1.7 million square feet is all intact, and then we would build on top of the parking additional uses, which may include residential, retail, additional office, medical office, a grocer, a hotel. All of these components are things that our tenants want and are looking for, and it's part of the reason that it attracted them to BRAA. These are a few renderings from the ground level, again, very conceptual. And this is kind of a proposed use plan. We are currently working with city staff to come up with a plan that we can agree on. As we move forward with rezoning, we're hoping to be on the agenda by the summer or the early fall to move forward with rezoning and site plan approval. Currently today, none of these amenities or uses would be available to the community at large. It would be exclusively for tenant use. And so that is why we are going to our neighbors and to the community to ask for their support, to offer, to answer questions, concerns, get your buy-in and approval, because this is something we really think will be a benefit to the community, and so we want community input and make sure that what we think the community wants, they actually want. So we do have online and in-person and physical letters of support that we can hopefully, bring with us to the city, to let them know that we do have the backing of the community. We would love to, like I said, love to have you on campus to tour the place. If you haven't been there, you really can't understand the opportunity that exists until you get in the four walls, or several walls, actually. And sharing our story with your community, your neighbors, your network, to help us build on that support. Any questions?
No. Well, I've been to some functions over there, and it's miles and miles and miles of hallways. Let me tell you, you can get lost there very simply. But you just hit upon something I want to mention. You did mention that in the future you might have residential. Now, would that residential be limited to the people that, or would that be open to the public?
So if we achieve rezoning for the campus, then it would be open to the public. Technically, we can't have residential at all, with the existing zoning, our existing zoning.
Well, I understand that, right.
But yes, we would expect it to be open to the public.
Well, the point I want to make is, we have been getting some noise complaints from that area, from our airplanes. This airport's been here for over 80 years. So I think in your planning, if you build residential or even office, you need to consider some extra construction to take care of any potential noise issues, because this airport is doing nothing but growing.
Absolutely.
I just want to mention that. I want to be on the record with that.
No, I appreciate that. And where we currently have the residential conceptually planned is the furthest possible away from the airport.
Okay.
That's the thing.
Randy?
Yeah, I mean, just kind of a word of endorsement. I've had a fair amount of involvement to, in attending events over there, and have gotten to know Gianna and Angelo, Bianca, who's the managing partner. They are, I think, a very good, affiliation or partnership for us, considering the type of tenant that they're, attracting, which is the private jet, type of companies. And they are very community minded, and, and are out there supporting the community. As Mel says, if you haven't been over there, get over there. I mean, it's nostalgic too, to kind of go in the elevators with the big mainframes went through and everything. And it's, so, I think, whatever we can be doing, from our board perspective or the staff perspective to support and work in conjunction with BRAA. And, you got the larger umbrella of CP, Crocker Partners, as well, that's, goes beyond BRAA, too. So I think it's just a natural affiliation for us.
I agree. Just following up on Randy's point, has there been any of the tenants so far that do have corporate aircraft, like Canon, or have any of them?
Canon doesn't have corporate aircraft that I'm aware of, but one of the reasons that they're located where they are is because they
Right.
have clients that come in very often.
So we might anticipate seeing some increase in traffic over the, right. For any of you that have been out in West Boca at the Uptown, this is a mini version, or that is a mini.
That's a mini version.
Yeah.
Yeah.
And it's incredibly successful. I was out there at the Naked Taco last week having dinner, and I mean, it's a great example of retail, restaurant, and residential, the 3 Rs.
So what lies the park?
And all working. And it's in West Boca, and if it can work, that can work there, this can certainly work here. So I think it is, a great thing for us to be involved in. My company is right across the street from BRIC, ADT, and I want to be a good neighbor as well, because this is good for attracting top talent to our area in a time of very competitiveness amongst tech companies. To have a great facility like this, it helps other feeder companies around, like ours, like Office Depot, and the other corporate employers in our area. So it's all good.
Oh, yeah.
Gene? Yes, sir.
Yeah, first of all, I was glad to see in your computer center you're using Mac computers. Can you tell us approximately what you envision as far as the number of residential units that you would like to see there?
So we're working with the city, to come up with a number that makes sense for both of us. I know that what we had initially proposed was 1,000 residential units.
How many?
1,000. We're not looking to, I mean, we have the space, but we're not asking anywhere close to what the capacity would be in terms of density. And we really anticipate that this will take cars off the road, because there are a number of employees who would love to work or live right where they work. And so, and we found Modern Rising Medicine said at a recent board meeting that they can't get executives to live in Boca because they can't find housing for them. The residential units, would look to buy a few of them just to keep for their employees available. So it is a benefit to the tenants, of course, the community at large, but we don't anticipate in necessarily adding more cars to the road.
You said they'd like to buy. Are these condos, or are you leasing?
We are office landlords and office owners. We would not own or manage residential.
All right.
So, we want to add additional uses so that can service the office part. But it's hard for me to say because I don't know who's going to be the one managing and developing.
Okay.
Thank you, John, appreciate that very much.
Thank you very much for your time.
Thank you, everybody. Next item is, authority board member requests and reports. Any issues, any comments from the meeting, or things we missed from any board members? Thank you all, appreciate it.
Thanks, John.
All right, hearing none, public comments. Is there any additional public comments? Did you get any cards? Christine? Okay. Any other business come before the board?
There's just one final item, Mr. Chair. A couple of members and I spoke during our one-on-ones about this special district issue that you've been reading about in the paper.
Oh, with Disney and DeSantis?
Right. So just for the record, the way I understand what's being proposed is any special districts created prior to 1968 would be the subject of this legislation. The Boca Raton Airport Authority was enacted in 1983, so it looks like we would be okay in that regard. And further, Lewis, Longman, and Walker, they have a lot of expertise and experience in dealing with special districts. So, if any questions were to come up in the future, I think we would be well covered with their.
I also said that, even though I know we're not covered right now, if it did hit us, what I've read is we would be able to renegotiate to get back to special district status.
Can we get raised then?
Are we going down that route?
Well, one of the now that Ms. Petrick is back, we're going to pick up on some of those topics that were put aside in dealing with the pressing matters of Premier that we discussed this evening. But there are other matters that we would address with regard to our lease with the state, so we thought perhaps we would bundle any kind of statewide issues together. That's probably the most appropriate way to handle any of those types of issues. So we're going to work on that as one of the to-do lists after we have an 11th Amendment.
Thank you for the heads up, though, appreciate that. Any other issues then? Okay. All right, our next meeting is May 18th, 5 p.m. right here in the conference room. I'm looking for a motion.
Motion.
Second. Second.
All right.
All in favor? Aye.